Welcome to the third and final session of this unit. Principle. Whoever being legally bound to furnish information on any subject to any public servant as such furnishes as true information on the subject which he knows or has reason to believe to be false has committed a punishable offense of furnishing false information. Facts. Savant, a landholder, knowing of the commission of a murder within the limits of his estate, willfully misinforms the magistrate of the district that the death has occurred by accident in consequence of the bite of a snake. How do we correctly analyze the principle? There are two conditions. One, a person should be legally bound to disclose some information to a public servant. And two, that person provides a public servant with information that is false or information that he has reason to believe is false. The word knowing tells us something. It tells us that these conditions are concurrent. They should both be fulfilled if we are to conclude that an offense has been committed. Now let's apply the facts. Was Savant legally bound to disclose some information to the magistrate? The answer is yes. Savant was most likely speaking to the magistrate under oath and so was legally bound to inform the magistrate that a murder has been committed. Secondly, did he provide the magistrate with false information? The answer to that too is yes, he did. So then we have to conclude that the offense of furnishing false information has been committed. The option that is closest to our conclusion is B. Savant is guilty of the offense of furnishing false information to the magistrate. Did you identify the correct conditions? Were you able to see that they were concurrent? Did you apply the facts to these conditions as I did? Maybe you did not, and if you disagree with how we applied the facts, then please leave a comment in the discussion forum. We look forward to discussing your points of disagreement. Maybe you can teach us a thing or two about how to break the facts down and apply them correctly to these conditions. Let's move on to our next question. Principle. When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Facts. Roshan, along with two of his friends, Tushar and Tarang, proceeded to the house of Darshan in order to avenge an insult made by the brother of Darshan. They opened fire on the members of Darshan's family. It was found that the shots of Roshan did not hit anyone, but the shots of Tushar and Tarang succeeded in killing Darshan. Okay, let's break the principle down. What are the conditions? There should be a criminal act done by several persons, and it should have been done in furtherance of a common intention. Both are clearly necessary conditions. If they are both satisfied, then we can reasonably conclude that each of the several persons is liable for that criminal act as if it was committed by that person alone. Now, let's apply the facts. Was a criminal act done by several persons? Roshan, Tushar and Tarang opened fire on Darshan's family and Darshan was killed by the shots. So the answer is yes. Was there a common intention? Again, the answer is yes, because Roshan, Tushar and Tarang went together to avenge an insult. So both conditions are satisfied. We therefore can conclude that each one of Roshan, Tushar and Tarang are guilty of the murder of Darshan. C. Roshan along with Tushar and Tarang was liable for the offense of murder of Darshan is the option that is closest to our conclusion. That should be our answer. Let's move on to the next question. Principle. Trespass to land means direct interference with the possession of land without lawful justification. Trespass could be committed either by a person himself entering the land of another person or doing the same through some tangible objects. Facts. A throws some stones upon his neighbor B's premises. The conditions are A, whether there is direct interference with another's property, and B, whether it was done without lawful justification. These are both necessary conditions if we are to conclude that there was trespass. Now, apply the facts. Was there interference with B's property? Yes, there was. Throwing stones onto B's land is clearly interference with B's property. In fact, the principle which states that trespass can be committed through tangible objects helps us here. Secondly, was it done without lawful justification? In the absence of anything in the facts, we have to assume that it was done without lawful justification. So both the conditions are satisfied and we can conclude that A committed trespass. The answer then is A. With this, you have come to the end of this video. We attempted a few more questions, but your practice should not end here. You should take any opportunity that comes your way to answer practice questions and to write tests. Just remember to apply the method you have learnt every single time. If there is any question where you feel that there is more than one way to identify the conditions or that you could have applied the facts in a different way, don't hesitate to start a topic on our discussion forum. At My Law, you are not just being instructed. You are also part of a great community of like-minded learners. Together, all of you can learn better. Never hesitate to ask questions and try answering the questions that others pose on the forum. By helping others learn, you learn better. That also brings us to the end of the videos that are part of this course on the legal aptitude sections of any law entrance exam. But your preparation should not end here. You may also be tested on your knowledge of law. To help you prepare for questions that may test your knowledge of law, you have in your hands reading materials where we have condensed our understanding of Indian law into easily digestible chunks. We have prepared these materials keeping in mind our analysis of previous question papers and the broad areas from which we believe your legal knowledge will be tested. These materials also contain many questions that you can practice with. Just remember to always apply the method that you have learnt. And what better way to test your preparation than to write mock tests? With this course, you have a few printed mock tests and a few others that can be taken in an online environment. Take all these tests very seriously. Make sure you challenge yourself against the clock and also analyze your results to see where there is room for improvement. Because that is how you learn, and that is how you will be at your best when you sit down to attempt any law entrance examination. Thank you for watching and best of luck.